So this is a golden nugget little case. You know, we have these piles of cases we keep on our desks that are just cases we just love because they're compact and small and little, and there's so much to them. This is a decision of our Court of Appeal just from this past October, and I believe Justice Daw, who you tell us the story.
I like him.
He was going to be an astrophysicist or something?
Something like that. Like super bright guy who I think was studying for a PhD in, I think it was astrophysics, and extremely bright, and then switched to law, thank God.
Yeah.
And was a great lawyer, and then became a judge in the Superior Court, did a great job, now elevated to the Court of Appeal, and I think, frankly, he should be on Supreme Court of Canada one day, but anyways.
Yeah, and a great writer. This is a great...
You know what's great about his writing? It's simple.
Yeah, I was going to say.
So it reminds me sometimes of how Justice Watt used to write. Like,
oh, yeah.
Justice Watt used to write things in a very funny, pithy,
I think
satirical way.
Yeah.
So Justice Daw doesn't do that, but it's like very clear, non-complicated writing and gets the point across very well.
Yeah. So this case, and it's obviously a sexual assault case. This involves a young girl in 2020.
Let's give the citation.
I didn't
Rex
do that.
v. JE 2024 ONCA 801.
Right.
Okay, go ahead.
No, I had a client ask me who's Rex on the case that he was looking at.
It's a dinosaur that we litigate against.
Yes, it's the T-Rex. I explained that to him. In any event, this stepdaughter made a complaint alleging that her...
I liked it better when it was Regina versus...
Regina?
People go, Vagina?
Vagina
no,
versus...
you're not...
Yes, here we go. Here we go. Beep. No, there's no beep on that. She basically alleged that her stepfather had sexually assaulted her when she was living with her mother and the stepfather. After a trial in the Ontario Court of Justice, the appellant was convicted of sexual interference, got a heavy sentence, 4.5 years imprisonment, and then he appealed against his conviction as well as his sentence. But it was a very interesting case because it was a vanilla case. It was a basic case. You know, Justice Daw referred to it as a 3-witness case. The father or stepdad, the mother, and the complainant gave evidence in this case. And most of the background was undisputed. Basically, the stepfather and the mother had met up outside of Ontario, moved to Ontario in 2012. And the stepdaughter eventually, or the daughter eventually joined them in Ontario. And then... things started going downhill after that.
Allegedly.
Well, no, they did start going downhill in terms of the daughter and her mother. They had a really strained relationship. They were fighting a lot. CAS was becoming involved because of the relationship between the mom and the daughter. And then, as we often see in these cases, the mother kind of sided more so with the stepdad because the daughter was being really destructive and out of control. And at some point, the daughter made allegations that stepdad had sexually assaulted her repeatedly. This seemed to coincide when mom started working late night shifts, so that was a bit of a coincidence in terms of the allegations, but nevertheless,
or as according to the Crown, opportunity,
as many times we've heard the Crown say, and you would have thought it'd be a relatively straightforward WD case for the judge, but
WD, what does that mean? We've only mentioned it a million times. It's the steps judges take in assessing the credibility and reliability of evidence of witnesses in a case. But, Justice Daw, black and white, he said, trial judge's reasons reveal that he took the wrong analytic approach to analyzing the mother's evidence, and specifically, he compartmentalized it from the rest of the evidence. So, in a nutshell, you're not supposed to do that, as Joseph will say very soon. Yeah, no, I mean, this is a very good cautionary,
it's a cautionary
Court of Appeal
case.
decision about how to assess evidence, in particular, how to assess defense evidence, and not create a different standard for analysis of the defense evidence. And that's what happened here.
And not compartmentalize and apply WD to each witness independently, which is what happened here. The trial judge here rejected the mother's testimony because, as Justice Dawes said, because he was not satisfied beyond a reasonable doubt that it was true. And that's just not the approach that the law mandates judges to take.
Let's frame the allegations a little bit so everybody can be positioned a little bit more. So the complainant described sexual abuse by the stepfather as always occurring, as Michael said, when the mother was either at work or asleep.
Right.
And at trial, the mother actually testified for the Crown, and it was also briefly called by the defense, which is a little unusual.
Yeah, it rarely happens, but...
But in any event, she testified twice. So the mother's evidence was relevant. Her evidence could not and did not directly refute the complainant's allegations of sexual misconduct.
Right.
However, her testimony was important to the defense because she contradicted the complainant on two contested issues. One, whether the complainant had disclosed the sexual abuse to her shortly after it started, and two, whether there was ever a time that the mother was away from the house for 2 days, which was on the complainant's account when the appellant came to her bedroom and tried to have sexual intercourse with her.
Right.
Those were the two areas that her evidence had relevance to the defense.
Right. And as Justice Dawes said, they were peripheral issues, but not inconsequential. I hate that word.
Not inconsequential. Yeah, and I wouldn't call them peripheral.
No. Well, Justice Dawes said they're peripheral to the sexual abuse allegations, but they were not entirely inconsequential, as he says. If the trial judge did not accept the complainant's testimony on these points, this could have raised about the mother. This could have raised a doubt about the credibility and other aspects of her evidence, including reliability and including her allegations against the appellant. So the judge was obliged to consider all of the evidence in deciding the issue, but he didn't. He compartmentalized the mother's evidence. And on page 7 of the judgment, you there?
Yeah, no,
we got to read this part out.
I just want to be careful about this because, although the judge refers to it, because I like Justice Dawes, peripheral to her sexual abuse allegations, and he says it's not inconsequential, my position is let's just call it relevant.
Right.
So if the trial judge did not accept the complainant's testimony on these 2 points, these 2 points that we've just discussed, this could have raised a doubt about the credibility and reliability of other aspects of her evidence, including her allegations against the appellant. And I often say this, and this is an important point, because it will be argued by the Crown that this evidence doesn't attack or strike to the core allegations of the complainant. It is collateral or peripheral. That's why I don't love those terms.
Okay, got it.
No, it's not. Because these were still important features of her evidence. How do you look away or excuse a complainant saying, I told my mother when this happened. And she was away for 2 days when he tried to have sexual intercourse with me. If there is evidence from the mother saying she never disclosed this to me, and I was never away for 2 days, and that evidence is properly assessed on the appropriate standard, the knock-on effect, which is a term I like to have, is it will have then an impact on the overall reliability and credibility of the complainant on the core allegation.
Right.
Period.
Yeah, that makes sense. So Justice Dawes goes on. He actually goes on to set out the judge's reasons that he was troubled with. So I'm going to read it all because it's important. And so while AR's testimony, and this is the mother we're talking about, I'll just say the mother. While the mother's testimony attempted at almost every opportunity to contradict the evidence of TRS, the daughter, I am skeptical of AR's testimony to the extent that I am unable to be satisfied beyond a reasonable doubt on the issue of her credibility, As noted previously, corroboration of the complainant's evidence is not required to sustain a conviction. He underlined that. I think Justice Daw was deeply concerned about that particular sentence from the trial judge's reasons. It goes on to say, and quote, while I've maintained an open mind and considered all the evidence presented at trial, I am of the view that the testimony of AR was considered and deliberate, excusing away any possibility that TRS was being truthful. The testimony of AR clearly indicated her loyalty to the appellant. This is also reflected in the choices made by AR prior to the alleged offenses. Her choice to move across the country with the appellant as opposed to staying in their original hometown for her daughter, and her writing a letter to the police after the appellant was charged, casting negative aspersions on her daughter. I do not find AR to have been a neutral witness. This casts a doubt over the denial by AR of TRS having gone to her initially in disclosing the sexual abuse. In light of the above, and having not received any evidence corroborating the evidence of AR, I'm left with doubt as to the credibility of the evidence of AR. I know there's a lot there, and hands are going to go up. We have to pause.
We have to remember that the trial judge found that he was not satisfied beyond a reasonable doubt that AR's testimony was true.
The mother.
Okay, that's the mother. Again, the trial judge's reasons revealed that he took the wrong analytical approach to the mother's evidence, compartmentalizing it from the rest of the evidence and rejecting the testimony because he was not satisfied beyond a reasonable doubt that it was true. So, he may have had valid reasons to have concerns about the mother's evidence because bias and interest are factors you can take into consideration to discount a witness's evidence. So if we call a defense witness who clearly is aligned with the accused, that may have a negative impact on the credibility.
Right.
Much like if a mother is called on behalf of the Crown,
right,
and the mother and daughter are closely aligned against the ex-husband,
right,
father, we will say, of course, that diminishes their credibility. But this judge clearly said that they were not convinced or satisfied beyond a reasonable doubt.
Yeah, and that's the red light.
Not the right standard.
Nope.
Okay, go ahead.
Yeah, so the passage we just read, Justice Daw says, again, quite simply and eloquently, this passage reveals three main legal errors. So error number one. First, the criminal standard of proof beyond a reasonable doubt does not apply to individual items of evidence. The trial judge improperly siloed the mother's evidence and seems to have then given her testimony no further consideration because he was not satisfied beyond a reasonable doubt that it was true. So that was a pretty fatal...
Yeah, that's a major
error. You don't pigeonhole stuff like that and then outright dismiss.
Which underscores why in many cases, if not all of our cases, if it's judge alone, we do written submissions and we have the framework of analysis, including WD standard of analysis. Like you can't...
The basics.
You can't allow somebody to f*** this up. Like, you just can't. But okay, sorry, go on.
That's okay.
Second,
I feel like I'm on Letterman. Second major legal error. The high criminal standard of proof only applies to the Crown's case against the accused, and more particularly to the essential elements of the charged offenses. The defense was not required to prove any contested facts, even on a balance of probabilities, let alone beyond a reasonable doubt. The trial judge, however, repeatedly indicated that he was discounting the mother's testimony because he was left with a doubt or not satisfied beyond a reasonable doubt about her credibility.
Fatal. Bad.
Bad. We should have a buzzer. Third main legal error.
Have a buzzer?
We
used to have something.
We got to get a buzzer back.
No, we had something. Okay,
Someone
go ahead.
stole our buzzer. Third, it was an error for the trial judge to treat the mother's evidence as requiring independent corroboration before it could contribute to a reasonable doubt. While the trial judge was correct to note that the corroboration of the daughter's evidence was not legally required, this was equally true of the mother's testimony. 3 strikes, you're out.
Yeah, but again, what's important is, you may presume judges know the law.
Well, that's what the Crown actually argued.
Well, clearly the judge didn't get it right.
Right.
Clearly, there was no requirement that a judge should be satisfied beyond a reasonable doubt about the mother's credibility before relying on it.
Right.
But the argument on the appeal was the Crown was just this, saying that, the judge actually did know the law and they are presumed to know the law and they kind of got it right later on in the analysis.
Right, right.
But Justice Daw, in the writing for the Court of Appeals, said that he didn't agree, and the majority, of course it's a 3-0 decision, did not agree that the trial judge's errors can be dismissed as inconsequential on the grounds that Ayer's evidence was unimportant. While it's true that the mother's testimony was not determinative of the appellant's guilt or innocence, and this is important,
right,
it was still potentially capable of contributing to a reasonable doubt, since there was no independent evidence that confirmed the daughter's evidence, the complainant's evidence, or the appellant's denials. The verdict hinged on the trial judge's assessment of their respective testimony, hence their credibility. I want to pause, and I want to say this again slowly, because time after time after time, we will be met with arguments, and it will be that this evidence does not strike to the heart of whether consent was given,
right,
which is the main issue in this case, or whether the sexual assault occurred. That is patently wrong. That is an untenable argument that we repeatedly hear, and if ever accepted by a jurist, will lead down the wrong path and can ultimately lead to a wrongful conviction.
So give an example of what the Crown argues.
We have many cases where you will have a complainant to be contradicted on some portion of evidence. Right. So, for example, we had a case. The complainant said, once I woke up, I realized I was still in his house. I realized that he had forced himself on me. I found my clothes. I ran out of the house. I literally just ran out of the house, got in my car, and I sped away as fast as possible. Okay. We had video evidence of her from the moment she was leaving. She walks out with my client. They walk out slowly. He hands her a bottle of water. They walk to her car. He opens the door. They talk for about 4 to 5 seconds. She sits in the car. He leans in. It looks like they have a kiss. She then talks to him for another moment, closes the door.
Slowly, yeah.
Slowly backs out and drives off. Okay? Well, that's real-time evidence about how they parted. Again, a Crown can argue to say, well, that's nice. She was maybe just exaggerating,
mistaken,
or embellishing or mistaken because of her heightened state of how she felt it panicked in the morning. That's exciting, but she was pretty clear in her evidence, right, both in her statement to police and what she said at trial, that this was her emotional state and the action she took once she got up in the morning and left. Right. The evidence that we had contradicted that. That, along with 2 or 3 other pieces of evidence, doesn't directly refute
the actual allegation. Yeah.
But here's what does, in a trial, refute the evidence of the actual allegation: the f***ing accused evidence.
Right.
Right? So this isn't in a vacuum.
Right.
In this case and in other cases, like I say, you got to have your client testify. He testified and said, I didn't do this. Right. Here's why. Right. So this evidence isn't in a vacuum. It's not that you don't call the accused, so you just have this minor pieces of evidence. This has to go into the analysis, right, with all the other evidence as to whether a reasonable doubt is raised. And this is exactly what Justice Daw is talking about. Yeah. So this evidence has significance, right, in raising a reasonable doubt in combination with the evidence of the accused.
Right. So you don't outright reject it in a vacuum, as you're saying.
You can't. And you will and we will have this argument time
forever,
after time after time, that these are minor inconsistencies that don't strike to the core of the allegations of the complainant or core of the evidence, and I'm sorry, that's not true. It is important because credibility, 95% of the time in these cases, is the central and defining issue.
Yeah, and it's often non-essential or non-critical pieces of evidence that add up.
It is the devil's in the details.
Yeah.
The cumulative effect of evidence like this, along with the accused evidence, can raise a reasonable doubt or can go even further and establish that the accused is telling the truth. Right. So it bears importance to repeat.
Right.
While it is true that the mother's testimony was not determinative of the appellant's guilt or innocence, it was potentially capable of contributing to a reasonable doubt, since there was no independent evidence that confirmed either the complainant's evidence or the accused's evidence. The verdict hinged on the trial judge's assessment of their respective testimony.
And it's also important that his reasons for judgment, I'm assuming it's a he, could have been a she, the trial judge's reasons were kind of sketchy. They weren't very detailed.
They weren't. But let's just raise one other thing, because we spoke about in another episode about the JJRD case,
yes,
which we keep talking about rears its head, even though there's pretty good law on how to deal with JJRD and how it's very specific. In this case, Crown Counsel urged the trial judge to accept the complainant's testimony as it was so compelling that the appellant's denials could be rejected, even if there was no obvious flaws in his evidence that could be identified. That's the JJRD decision. And in a previous podcast, we went through the case law. I think it was an hour.
Right.
I think that we went
through. It was a long one.
All the case law about it. And we established very clearly that there's lots of case law about how you do the analysis, and the JJRD decision does not detract from the WD analysis. It's still alive and well, and the JJRD case was only what it is simply because there was in that case a diary that had real-time notations about the actual allegations themselves, which rebutted an allegation of recent fabrication. So the Crown in this case, and this is why I say where they play fast and loose, right. The Crown in this case tried to argue that the complainant's evidence in and of itself, without a diary, without any sort of other corroborating evidence, was so compelling that it overcame the accused evidence that had no obvious flaws. So in this case, any evidence that could possibly have undermined the complainant's credibility or reliability, even on peripheral points, was potentially significant.
Yeah.
Okay.
Imagine that.
The defense counsel in this case chose not to directly go head-to-head with the complainant on her credibility, which is sometimes a judgment or tactical decision. We do almost always go head-to-head with the complainant on their credibility. But even in this case, where it was not directly put into issue by counsel for the accused, the Court of Appeals still said it still went, credibility was still not off the table. To find the appellant guilty, the trial judge still had to be satisfied beyond a reasonable doubt that the mother's evidence was both, that the complainant's evidence was both credible and reliable. Mm-hmm. And in any event, the mother's testimony had the potential to cast doubt on the reliability of the complainant's memories, as well as on her testimonial credibility. Really important facts to remember going forward in any case where you're arguing about reliability and credibility. Right. Especially when you're faced with that JJRD decision where they're trying to shove it down the throat, and where they're trying to say, like I'm repeating now over and over, where they're trying to say this is peripheral, collateral, non-relevant evidence.
Okay. Explain JJRD again.
Please don't.
Just once. You can do it. You can do it.
Okay, so this was again a case. It was a stepdaughter or a daughter complaining about sexual abuse. But in that case, it was actually a daughter. The defense was that there was a motive to fabricate, something about the daughter aligning herself with the mother, and then it coincided with the time that she refused to see the father, and it was an allegation of recent fabrication. In other words, the defense was that she made it up because of these issues. Mm-hmm. There was a diary in question that was cross-examined on by the defense, and it was relied on by the Crown, because the diary had recording about the abuse that predated when the accused was saying that there was this motive to fabricate. So it rebutted the recent fabrication allegation.
Right.
Therefore, that was some independent evidence circumstantially giving credibility to the complainant's testimony and then the trial judge was able to rely on the combination of this evidence to overcome the accused evidence. So to prefer the complainant's evidence over the accused, even though there was no obvious flaws with his evidence. Because one, There was an argument front and center by the defense of recent fabrication that was then nullified by the diary. Therefore, there was this other piece of evidence that gave this compelling nature to the complainant's evidence. That's why he was convicted.
Right.
That is a very unique set of facts.
Yeah.
Not generally applicable to all sexual assault cases.
Right. Yeah, I know.
I get bothered by it because there's a lot of good Court of Appeal decisions afterward. There's Justice Pachaco's article, Doubt About Doubt, which does an outstanding job of going through the reformulated WD analysis and how to go about this. So when you see this again in case after case, JJRD is applied to very limited facts that you will not have in every sexual assault case.
Right, right.
So in spite of that, Justice Daw in the Court of Appeal was very good to caution to say, even though the credibility of the complaint was not directly taken head on, it didn't take it off the table. No. And the mother's evidence was relevant to the daughter's evidence, both on credibility and reliability.
Right.
And
then
you raised a good point now with paragraph 26 is this became all the more important because
sparse trial judges' reasons for rejecting the appellant's denials or for accepting the daughter's evidence.
This is important because we talk about this often and why it's important to have detailed reasons from the judge.
Trial judge said, in reviewing the evidence of the appellant, it is difficult to overlook his practice of acknowledging facts which are benign to the allegations, while all else was denied with varying degrees of explanation.
He gave no other explanation for rejecting the appellant's testimony for accepting the complainant's evidence apart from his finding that he was not satisfied about the mother's credibility beyond a reasonable doubt. It was a dearth of reasoning here.
Yeah, that was bad. And then the Crown tried to backpedal on this, but I don't think, as Justice Dawes said, trial judge did not simply misspeak because the Crown was trying to urge, the judge kind of got it eventually. He figured it out. But no, the Crown Counsel's argument was he was urging Justice Dawes, the panel, to conclude that the trial judge did not really mean what he said in his reasons for judgments. That's a new one, but Crown Counsel...
No, I've heard that before.
You've heard that one before?
Yeah.
Okay, he didn't really mean that, Court of Appeal. Crown Counsel notes that the trial judges are presumed to know the law and observes that elsewhere in his reasons, the trial judge correctly instructed himself that individual items of evidence are not to be subjected to the standard of proof beyond a reasonable doubt, which applies to the essential elements of the offense. Crown argued that the trial judge's reasons as a whole show that he did not reject the mother's testimony merely because he had a reasonable doubt about her evidence. So again, Justice Dawes said, I don't accept these arguments. Justice Dawes said, quoting Moran as a 2024 Ontario Court of Appeal judgment.
This is another important Court of Appeal decision.
It is. Although trial judges are presumed to know the law, this presumption does not entitle appellate courts to ignore what trial judges actually say in their reasons. A corollary of the judicial duty to give reasons is that when reasons are given, they should generally be taken seriously and at face value as an accurate reflection of their author's thought processes. Then Justice Daw goes on to say, it is difficult to dismiss the trial judge's repeated statements in his reasons that he was rejecting the mother's evidence because he had a doubt about her credibility as a mere slip of the tongue. So this wasn't just a mistake. This was something the trial judge said repeatedly during the course of his reasons.
Yeah, and let's pause again. So the Morin decision is a sensitive case because it deals with a decision, if I'm correct, about prior consistent statements and how they were used at that trial. Just happens to involve a trial judge at the time who now sits on the Supreme Court of Canada.
Right.
So you need to understand the sensitivity of the Court of Appeal rendering a decision in 2024 about a trial judge who at the time of the Court of Appeal decision sits on the Supreme Court of Canada.
Right.
Okay? Not casting any aspersions on her honor. That said, they made a very clear point. Although trial judges are presumed to know the law, this presumption does not entitle appellate courts to ignore what trial judges actually say in their reasons. Very
huge.
Very important.
Yeah.
So if a trial judge is seen by their reasons to get it wrong, they get it wrong. There's no
we don't
pass
fix it.
given.
Yeah, there's no pass. Yeah, and he goes on to say, the legal errors I've identified go beyond the trial judge subjecting the mother's testimony to an unduly high standard of proof. It was not the defense's burden to establish that the mother was more believable than the daughter, either on a balance of probabilities or beyond a reasonable doubt. That's significant.
Yeah, rather, to properly apply the criminal burden of proof to the Crown's case, the trial judge had to critically assess the complainant's testimony in light of the evidence as a whole, including the mother's testimony, even if it did not affirmatively accept the mother's evidence as proved to be true. The trial judge's reasons do not show that he engaged in the essential analysis.
Yeah, there's no patch up here.
So therefore, this got conviction overturned, back for trial. This is, I now think, when we... It's great that we get all the Court of Appeal decisions and we stack it on our desk and we finally get to read it. Exactly. But this is one of those, I think, you might think, it's a good case, but, it doesn't have that much precedential value. This is a very good case that I think I'm going to include in my written submissions, and I'm going to take nuggets from it.
That's why I call it a nugget case, Golden Nugget.
Just for me about how you assess evidence from the defense. Right. And it's not that we're insulting a trial judge while putting it into our reasons. We do a framework of analysis. We go through WD Standard. We go through Justice Pajaco. We address JJRD. We adjust the cases that then, properly contextualize the JJR decision. And this is one of those cases I think we're just going to add in where it is extremely helpful in showing that you have to be careful about the burden to which you scrutinize defense evidence, which extends to a witness other than the accused, right. And that even though facts may seem to be peripheral, it can still be very relevant,
of course,
to creating a reasonable doubt in conjunction with the accused evidence.
Exactly.
This, to me, is a quiet but very important decision.
Yeah, it is.
And again,
it's a keeper.
I love the simple. I love the very coherent, nice, easy writing. Yeah. It's a very good case, and it again. I don't mean to say that Crown attorneys or judges try to get it wrong or want to obfuscate what is properly the legal principles, but it does happen. Right. And we are regularly met with this JJRD argument, which we spent, I think, an hour and 3 minutes talking about in the recent podcast. And this is why it flows in. Very good decision, and a very good decision on the issue of credibility. I can't tell you how many times on 276, 278 applications, when we lay out the entire history and why a piece of evidence is relevant, and we're trying to cross-examine on it, and it just happens to be other sexual activity or document in question or something contradicting the narrative of the complainant, you're met with complainant's counsel and sometimes the Crown saying, well, it doesn't assist with the credibility of the complainant, right. And that's not really the issue. The issue is about the consent.
Right.
And it's like you have to keep going back to first principles going, no. Credibility is the central issue here.
That is the issue.
It does not have to refute the specific allegation of sexual assault.
Right.
But it can refute other pieces of evidence in combination with the accused denial that can raise a reasonable doubt.
Cumulative effect. You would think it's...
I don't know how many times I have to say this, but it keeps coming. And we've said it time after time. It will come up, and it will come up, and will come up. So whether you're, stuck on your own defending this, or if you're a lawyer defending this is a great case to include in your submissions, whether they're written or oral, because it's a good cautionary tale that all evidence is important when called by the defense.
It's a keeper.
Okay, well, I hope you found this as important as we did. So, pillow talk.
Yes.
I'm going to give it to you.
Thank you. It's been so long since I hugged the pillow. Well, it has. So, folks, don't forget to like, comment, subscribe, and share. And
keep sending us emails and keep commenting, because it's so helpful to us framing these.
And join us live on Sunday nights. We are sitting there waiting.
Those are great. So when the podcast drops on a Sunday night,
join us.
We're getting a lot of, we have a lot of our people who commonly watch it when it drops. We get a lot of interaction, excellent questions that you can address right then. It's a lot of fun. We really enjoy it.
You're allowed to curse in the chat too, so it's great.
And hopefully tomorrow we'll have a really good fundraiser.
We will. I'm looking forward to it.
You're coming out tomorrow. We have our annual Feed the Hungry fundraiser to fight food insecurity. And
it's going to be great.
We've raised $16,290 this year.
And growing.
Yeah, I was trying to get to $20,000, but what do we call it? Billiards for the Bar. I've been doing this since 2014,
Forever.
I think.
Wow.
So, yeah.
That's a great cause.
Good night, everybody.
It's not too late to buy tickets.
Well, by the time they see this, it will be.
Well, that's true.
But this will drop Sunday. We're going to shoot pool tomorrow night.
True. Maybe we can tweet.
Maybe we can go back in time through the wormhole.
Through the wormhole.
In Interstellar. And
NCC.
And then get them
whatever
to buy
that term
tickets
was.
then.
Exactly.
Good night, everybody.
Bye-bye.
Boy, we're geeks, eh?
Yeah, total.